When it comes to life sciences, there's common technologies that go from pharma to agriculture to forestry to almost any type of industry that has a life science basis. And you could look at it as a trunk of a tree where there are some core technologies that really support that all the branches on the tree. I think the challenge really becomes one, is understanding where the splits are along the architecture of that tree, and really how far that main trunk can take you out before you have to do some things that are very different. In our case, we were very successful because the core technology that we transferred was something that could be applied across different sectors into different applications. I think the real challenges of that come into intellectual property law and intellectual property protection, where it's often difficult for patent offices to understand that a technology, and enabling technology in particular, has the ability to go across a broad set of applications. And intellectual policy and intellectual law generally requires you to demonstrate the applicability of that technology across these different sectors, and most organizations don't have the strength or the time to do that. So we have a little bit of a challenge here in terms of taking something that has a broad application and clearly defining where we want to go in order to demonstrate that it is applicable across those different areas. I don't believe there are junk patents per se. I believe there are patents that don't become useful or valuable because they were perhaps patented too early, or that the people who went to seek those patents really didn't understand what the applications are. I mean, no matter how much you spend on a patent, it's not worthwhile unless that patent, A, is generating some form of revenue or product associated with it, and B, brings some sort of benefit, whether that's economic or whether it's social benefit, to society as a whole.